Hello, welcome to our fourth webinar in our short series of immigration webinars. Our first webinar was an introduction to sponsorship, delivered by my colleague Callum. He also delivered the second webinar, which was about key personnel, primarily the responsibility of the Level 1 user. The third in the series, delivered by myself, was in relation to sponsorship duties and the obligations of the sponsor whilst holding a sponsorship license. And the fourth webinar discusses immigration compliance audits. Audits can take many forms. They may occur through a site visit during the initial license application, or at any time during the course of the license validity. More frequently, we are seeing requests for further information from the Home Office using questionnaires and also video call interviews with caseworkers. Before we get started, I should flag that this webinar will make reference to topics discussed in our early webinars. If you are entirely unfamiliar with sponsorship licenses or the terminology, I would recommend that you first watch the Introduction to Sponsorship webinar, which is available on our website, as this provides much of the background upon which this webinar is based. So why should sponsors be concerned about sponsorship compliance? Well, as I said in one of my earlier webinars, sponsorship is considered a privilege, and the Home Office place great trust in sponsors to undertake their obligations in accordance with immigration law and guidance. There has been a sharp rise in the number of sponsorship registrations since Brexit, with now over 100,000 businesses on the public register. The Home Office cannot physically visit all sponsors, but they can undertake various types of compliance checks to ensure those sponsors are maintaining compliance with their sponsorship duties. So just to give you an idea of action that has been taken as a result of those compliance checks. We've seen a dramatic increase in suspensions and revocations of licence. This year in quarter 1 and 2, we saw 833 licences suspended and 709 revoked. Compare this to last year when there were 569 suspensions and 337 revocations across the year. Compliance checks and visits are tools that the Home Office use to assess the business's eligibility to sponsor migrants. We are now seeing visits on the rise again. So for existing sponsors, the Home Office are checking that sponsors are compliant with its sponsorship duties and that any proposed sponsors can demonstrate the ability to meet sponsorship requirements. Compliance visits may be announced or unannounced, so it's important that key personnel contact details remain up to date, in particular the authorising officer, as this is the primary contact for the Home Office if a visit is required. Now, many of the visits are unannounced, as the Home Office do not want sponsors or speculative sponsors to change their working practices or their environment solely for the purpose of the visit. There are two types of visit. There's a pre-license assessment visit or a post-license compliance visit. These are very different, with the post-license compliance visit being much more about reviewing compliance documents and processes. However, the pre-license visit could also involve reviewing current practices for all employees rather than just the migrant workforce. Some factors may trigger a visit. Potentially high-risk sectors such as hospitality, care or retail. They may be as a result of an online check by the Home Office from information available at Companies House, information sent through to HMRC on PAYE records, or other relevant regulatory bodies such as the Care Quality Commission for the care sector. Another trigger could be a sudden increase in the number of workers, a change in business structure, where an organisation has multiple branches, or where there's an increase in remote working. Quite often, a trigger could be a tip-off from an external source or a third party been made to the Home Office. I will now look at the purpose of each of these types of visits. So why would the Home Office require a pre-licence assessment visit? Well, they may feel there is a potential threat to immigration control from information in the public domain. It may be that additional checks are required for a specific sector, as I mentioned earlier, the care sector, hospitality sector, or indeed the retail sector. There may have been information that caused concern contained within the licence application or in the supporting documents or the covering letter or information that has been available in the public domain. It could be that the key personnel who are nominated on the licence have a poor history of immigration control, or that they were previously on a licence that was revoked or had immigration compliance issues. The pre-licence assessment visit is not a prerequisite of being granted a licence, but failing to demonstrate the ability to comply with sponsorship duties could result in the non-grant of a licence. So how should an organisation prepare for a pre-licence visit? Sponsors must be able to demonstrate the 5 key areas of responsibility in maintaining sponsorship duties. They must have a robust HR system and processes for monitoring immigration status. They should also be capable of maintaining contact details and work locations for their workers. They should demonstrate accurate record keeping and recruitment data if applicable. They should also be able to demonstrate they can retain documents for all mandatory information, including right to work, references, DBS certificates, payslips, etc. Their systems should also demonstrate the ability to track migrants' whereabouts and monitoring, particularly in line with the organisation's handbook policies for holidays and absences, etc. If the Home Office have requested a visit, please ensure key personnel know where all of the documents are saved, particularly from the licence application, and that they are familiar with any content and sponsorship duties. Caseworkers may check personnel files, look at passport copies, right to work documents. They may also interview workers and key personnel to ensure they are aware of the sponsorship duties. They may check internal systems and policy to ensure policies are being followed and any updates have been made. And finally, the caseworker may also review the business type, purpose and size to ensure that the number of migrant candidates they wish to sponsor is appropriate for the size of the business. For example, a small organisation recently established in the UK requests 20 certificates of sponsorship. Can that sponsor demonstrate the need, their requirement for sponsorship? The caseworker may also inquire as to the business reasons for the request and whether the organisation is capable of offering the relevant employment and the appropriate skill levels and pay them at the appropriate rates. And finally, another issue that does arise in the pre-licence assessment is in relation to the pay rates across the business, particularly against other employees, and whether or not migrants are being paid more just to meet the salary requirements. Now, before moving to the post-licence compliance visit, let's look at a request for information which is sometimes used instead of the pre-licence visit. So some sponsors may not get a site visit and instead they are asked to provide further information to support their licence application. This is usually a checklist or a questionnaire, and quite often the questions we see would involve the sponsor having to confirm they have read the guidance and understand the responsibilities of sponsorship in all aspects, including record keeping, monitoring status, maintaining records, contact details, and migrant tracking. They may also ask for a full organisational list with roles, the names of all employees, and their nationality. They may also ask for a contract of employment, which must comply with UK law and is signed by both parties and sets out clearly the duties, the hours of work, benefits and rates of pay. Let's move on now to post-license compliance. The post-license visit will usually be more complex compared with the pre-license assessment. However, there are many similarities. Triggers are often similar to the pre-license assessment too. The Home Office may look to information held at company's house, information presented to HMRC, or again, relevant regulatory bodies such as the Care Quality Commission. Where a sponsor is issuing lots of certificates of sponsorship, where business structures or changes are discovered on company's house but not reported via the sponsorship management system. If a business has multiple branches or remote working and therefore not reporting accordingly. Again, sometimes the triggers would be in relation to the risk and where the business operates, such as care, hospitality and retail. And similar to the pre-assessment, Home Office may receive information from a third party via tip-offs. The Home Office will always review the sponsor's HR processes to assess whether sponsored workers were recruited to fill genuine vacancies, whether the sponsor has a legal trading presence in the UK, whether the number of certificates of sponsorship requested or granted is justified, whether sponsors are complying with their visa conditions, in particular students working outside of their permitted hours or those who are undertaking supplementary employment. The caseworker will assess whether there is any genuine threat to immigration control. For example, are there any civil penalties issued for illegal workers? Is there evidence of criminal activity? Is any information available on the migrant worker applications that doesn't quite tie in with the sponsor's organisation? Are there any reports from other regulatory bodies? And the final element of the post-license compliance visit will be interviews with key personnel and migrant workers. The caseworker will almost certainly interview the migrant workers to ensure the migrant is undertaking duties as reported on the certificate of sponsorship. Additionally, the migrant site address should be recorded correctly. If a migrant is recorded as being on site, the caseworker will expect to be able to see them. Does the certificate of sponsorship have the appropriate duties? And again, this can be collaborated by the migrant in an interview. Caseworkers can also turn up to third-party sites, so it's important that your clients are aware of the possibility of a visit from the Home Office. I just now want to give you an example of some of the areas that were highlighted in visits where the Home Office have taken action against the sponsor. Where a salary has been recorded incorrectly and the sponsor has been recovering costs from those migrants. I'm sure you're aware, but sponsors cannot pass the costs of the skills charge and the certificate of sponsorship assignment fee to their migrants. They will ask to see payroll information. There are similar issues with topping up salary for living costs. Again, it cannot be included to meet the salary requirements for the role. There were other issues identified for genuine vacancy, where migrants were undertaking duties that were not recorded as part of the role they were employed for. Similarly, recruitment records were identified for different roles than the migrants were offered. There were other issues with the monitoring of the immigration status. Some sponsors had no records of the visa expiry dates, or they were recording the wrong visa dates. Other cases where sponsors failed to demonstrate right to work checks for all staff. There were also instances of poor record keeping where sponsors failed to report sickness absences and holidays in line with their policy guidance, where addresses were not recorded by site, where contact details were not kept up to date, where start dates were not updated, and other information picked up specifically at interviews, which did not tie in with the sponsorship contracts of employment, where migrant workers were not given statutory holidays, where DBS checks were not conducted until after employment, and others as where the migrants were used solely to avoid recruiting from within the UK. Now, some of these compliance issues may appear negligible alone. However, cumulatively, they could result in serious sanctions against the licence. So let's now look at the impact of non-compliance to sponsors. So what is the impact of non-compliance on a sponsor? Well, if the non-compliance is discovered during the pre-license assessment stage, it's unlikely the license will be granted. If discovery occurs during the post-license stage, the license may be downgraded. An A-rated license may be downgraded to a B rating if a sponsor does not continue to meet their sponsor responsibilities. If this does happen, a sponsor will not be able to issue any new certificates until improvements have been made and the license has been upgraded back to an A rating. Sponsors will still be able to issue certificates to workers where they require an extension. Sponsors must also agree to an action plan and pay a fee of £1,476 and then demonstrate improvements have been made before the licence is upgraded back to the original A rating. If the non-compliance is more serious, the Home Office may suspend the licence. If the sponsor is believed to be breaching duties or pose a threat to immigration control, or in fact they're engaging in actions that are not conducive to the public good. In these circumstances, a sponsor cannot assign any certificates of sponsorship, but they must continue to comply with their sponsor duties throughout the period of suspension. Usually, a sponsor will have an opportunity to address any non-compliance issues in a follow-up letter, which the Home Office will then assess together with any supporting evidence within 30 days of receiving all of the information to support reinstatement. Finally, if more serious breaches are discovered, the Home Office could move immediately to revoke the licence. Now, some reasons that the Home Office would revoke the licence immediately is if they discovered a sponsor ceased to have or never had a trading presence in the UK, they had ceased to meet the requirements of sponsorship or the route they were licensed in, they discover a serious or systematic breach of sponsorship duties, there is an immediate threat to immigration control, an individual has been convicted of a relevant criminal offence, or there is evidence that the key personnel are engaging or have engaged in actions or behaviours that are not conducive to the public good. When a licence is revoked, the migrants will have to find another job or leave the UK within 60 days of the notification received from the Home Office. And if during a visit the Home Office discover illegal working, the sponsor could face civil penalties of up to £60,000 per illegal worker, and any employee of the business who knowingly employed that illegal worker could face a prison term of up to 5 years. So my key message here is be prepared if the Home Office come calling. Make sure the authorising officer, key contact, level 1 user and any representatives are ready to answer any questions and have easy access to information and documents retained for sponsorship. Make sure there are robust HR processes in place and they're all well managed. Make sure all reports of changes on this are reported on the sponsorship management system in relation to the organisation and any migrants. Make sure key personnel contact details are up to date. Maintain accurate files for migrants using the checklist extracted from Appendix D. Cooperate with the compliance officer. Answer only questions you're answered. Do not give any additional information. And finally, conduct mock audits regularly. Now, in relation to mock audits, how can we help? Well, we can undertake a mock audit for you or advise you how to undertake the process. Mock audits or regular audits will help you remain compliant with all immigration and sponsorship requirements. The guidance and law is made up of numerous documents, web pages, and is sometimes difficult to keep track, particularly when the rules change so frequently. Ensuring you have right to work documents, systems, and processes in place to check for any repeat checks where these are required for visa expiries. We can advise you on the processes to avoid discrimination, assist you in reviewing migrants' visa conditions, particularly in relation to students or supplementary workers. It'll help you address any sponsor licensing duties in relation to your license. Key personnel changes, any changes of circumstances that are required in relation to certain timelines. We will assist you in knowing your sponsorship duties, ensuring you know what needs to be reported and when. Ultimately, audits can help resolve any areas of non-compliance and avoid those sanctions and financial penalties. Managing a sponsor license can be quite a daunting prospect, particularly for a level 1 user with little experience of the sponsorship management system or knowledge of immigration practices. We spoke about our retainer service in the level 1 user webinar, where we can be added to your license as a level 1 user and manage the license on your behalf. This includes reporting changes of circumstances, applying for and assigning certificates of sponsorship for your workers. Part of our retainer, we also carry out an annual health check on the license to ensure that all information is up to date. We also provide checklists of your sponsorship duties so that you can be clear as to what information needs to be passed to us to be recorded or reported on the sponsorship management system. We can also provide training to users level 1 or 2 users if required. Well, that concludes my talk on compliance audits. If you have any questions about sponsorship generally or would like to hear more about our audits or our retainer service, please do get in touch with me or one of my team. We share content regularly on LinkedIn, so please connect with me for regular immigration bulletins. Thank you for your time. Take care and have a good day.